Okay, Chapter 4, Video 6, we're still focusing on constitutional law, particularly as it affects business. Okay, so now we're talking about the Equal Protection Clause. There's a lot of interesting things about the Equal Protection Clause. First of all, the main provision is found in the 14th Amendment, which was a post-Civil War amendment meant to cure the law's unequal treatment of blacks and whites as a result of slavery and other things. So that the 14th Amendment says no state can deny a person the due process of law or equal protection. This is sort of a flip of the earlier things we talked about, where the first 10 amendments only apply to the federal government and equal protection, and the 14th Amendment applies to the states. Well, equal protection is not in the first 10 amendments. However, in a sort of flip way, the Supreme Court has ruled that the Fifth Amendment Due Process Clause actually protects people against unequal protection, or guarantees equal protection under the Due Process Clause. So again, it's sort of a reverse incorporation doctrine, and so both the states and the federal government cannot deny equal protection. Now, equal protection, as interpreted by the Supreme Court, is a little bit difficult to understand. And it's basically just applying some rules that the courts have adopted over the years. Okay, so there's basically three rules that apply, and we call them scrutinies. What do we mean by that? We mean that when a state or the federal government passes a law that appears to treat groups differently, we're going to apply different levels of scrutiny to determine whether or not they're legal discrimination. Okay, the highest level is what we call strict scrutiny, and that is a situation where there is a law that treats two classes of people differently. So the typical historical thing would be where it treats blacks and whites differently. So if blacks have to go to one school and whites have to go to another school, we have a classification, is what we call it, a classification based upon race. And that is where we apply strict scrutiny. And in those situations, the rule is that the government has to have a compelling government interest. The reality is that it never passes strict scrutiny. Any kind of classification like that is almost assuredly going to be declared unconstitutional. Okay, so what are the types of classifications that are treated with strict scrutiny? They are what we call immutable classifications. And so what do we mean by that? Generally what we mean is that the people who are classified have attributes that they were born with, that they can't change, and that have a historical discrimination against. Okay, so for example, if you're black, you're born black, you can't change that, there's been historical discrimination against you. Okay, so that's the strict scrutiny level. At the bottom level is what we call the rational basis level of scrutiny. The rule with rational basis is that when the government creates two classifications that are based upon this lower level, that they only have to have a rational basis for doing so. So the rule of thumb is that if you fall in that classification, the government is always going to be upheld in what they do. So some of the areas with that include the rational basis test include wealth, for example. So a classification by the government which classifies rich people and poor people a little bit differently was probably going to be upheld. And there was a case, a school case that involved that was found to be okay. All right, so the Supreme Court had these two tests, and then along comes, guess what? A situation where the laws were different based upon gender. So the Supreme Court struggled with this, and they had a hard time coming up with an agreement, whether it should be strict scrutiny or rational basis. So they ended up compromising and creating what we now call the intermediate test. Okay, so the intermediate test applies a little bit lower level than a compelling state interest, much higher than a rational basis. Sometimes the government wins, sometimes they lose. The areas of classification generally are sex, legitimacy, sometimes I think mental health as well. So those are some of those areas. All right, we talked about procedural due process, substantive due process, fundamental rights in the last video. We're talking about equal protection. And here's the 3 levels. And I think I covered all that. Now, privacy is an interesting one. Nowhere will you find in the Constitution or the amendments any mention of a right to privacy. So the first major decision in that area was a case called Griswold versus Connecticut back in the late 60s or early 70s. And this was a case where Connecticut had a law that made it illegal for doctors to counsel their patients on contraception. So that was challenged by the doctors and the patients, and the Supreme Court ruled that a woman had a constitutional right to privacy that included the right to be counseled with regard to contraceptives. What followed from that was in 1974 the Roe versus Wade case, in which the Supreme Court ruled that a woman has a right to privacy with regard to the health of her body and what she does with her body, and that triggered the right to privacy. And of course, Roe versus Wade has been interpreted and limited in subsequent cases, particularly Casey versus Pennsylvania. But back to the right to privacy. So where did the Supreme Court come up with this right to privacy? It's not exactly clear. Some say it comes from the Fourth Amendment, some say it comes from the Fifth Amendment, some say it comes from the Ninth Amendment, some people say it comes from the so-called penumbra, which means that all these rights under the first 10 amendments would not be meaningful unless you had a right to privacy. Some say it's a natural right that we have that doesn't require protection by the Constitution. Whatever it might be, it now is, 50, 60 years old, but it's still controversial. There are still judges, for example, even on the U.S. Supreme Court, I believe Judge Thomas follows this philosophy, that there is no constitutional right to privacy. Okay. However, privacy, in addition to constitutional protection, also has some statutory protections. The Freedom of Information Act, which allows us to get information from the government, but protects some of that information. The Privacy Act, HIPAA, which you're familiar with, protecting patients' records, the U.S. Patriot Act, and the USA Freedom Act. Okay, so that completes Chapter 4. Again, the magic word for Chapter 4 is Constitution.